At the Media Council of Kenya, we can confirm that after lengthy discussions and involving consultations with the Committee in charge of Energy and Information of the Parliament, that we have led the discussions and have managed to broker a deal to amend contentious issues that have been viewed by Kenyans in general and the media in particular as constraining and as constraining to the media freedoms in this country, including the freedom of expression as provided for in the Constitution. In an attempt to actualize the Constitution, Article 34, subsection 5 of the Constitution, Parliament had passed the Kenya Information Amendment, Communication Amendment Bill 2013 on 31st of October 2013, which the President subsequently declined to sign, citing the inclusion of unconstitutional provisions, particularly related to Article 34.5 on media freedom and freedom of expression. Similarly, Parliament is scheduled to finalize a debate on Media Council Bill 2013, which has some provisions that violate fundamental principles of freedom of expression in terms of its structure, its independence, the composition of the members, and the role of the Complaints Commission in media regulation in a free and democratic environment in Kenya. A consensus has been reached, and it has been reached in the following manner: that the KICA bill will only regulate infrastructural issues in connection with media, which include licensing, signal distribution, courier services, postal services, telecommunication services, among others, to regulate the same that will fall within the ambit of the KICA bill. All issues to do with the ethical conduct of journalists and of media enterprises will be handled within the Independent Complaints Commission of the Media Council of Kenya, and not as proposed to be handled within the Communications and Multimedia Appeals Tribunal set in the KICA bill. The fines of 20 million shillings for media enterprises and 500,000 shillings for journalists within KICA bill will only apply to persons and media enterprises that will contravene that particular act and the provisions of the act of the KICA bill, and not matters related to the code of conduct of journalists or the code of conduct of media enterprises in relation to ethical issues. This will be handled as has been handled within the Complaints Commission of the Media Council of Kenya. However, matters relating to the broadcasting code of the media enterprises have still been left within the KICA bill under the authority of the CAK, and to be handled within the tribunal that is now being formed within the KICA bill under the new Communications Authority of Kenya. The members of the tribunal will be nominated by a selection panel from the industry, and they will forward the names of the chairperson and the members of both the authority and the council to the CS only for gazettement. Therefore, there will be no leeway, there will be no hand of government in the appointment process, and there will be no leeway to even change what the selection panel will have proposed as the names to make up both the authority, the tribunal, or the Media Council of Kenya, the board, or the Complaints Commission. So the selection panel is absolutely independent in view of the propositions that we have made. With regard to the Media Council bill, we have agreed as follows: that the decisions at the Media Council can only be appealed at the High Court. Therefore, the Media Council, decisions of the Media Council or decisions of the Complaints Commission cannot be appealed within the tribunal held within the KICA bill. This will only be appealed within the system set in court, and that is the High Court of Kenya.